The opponents will go first, Mr. McNeil.
I'd really be remiss if I didn't start out by really thanking you guys. I have to compliment you. In my opinion, this board has gone above and beyond the call of duty in allowing all parties to be heard. I recognize that for some of the residents it may have seemed a little frustrating at points, but that's the process. That's not anything that the board did. It's just the nature of going through these proceedings. And I think everyone here appreciates the time that you've devoted to this, especially in light of the large salaries you probably receive for attending these hearings. With that being said, in any case, when you start in law school, there's two things that you think about. There's obviously the facts of the case, and then there's the legal issues in the case. After listening to my client, Sonia, speak tonight, I don't think I have to spend a great deal of time discussing the facts of this case with you, the reasons why, factual reasons why people are opposed. So primarily, I'd like to just spend a couple of minutes of your time outlining the legal process argument that exists in this case, and just touch very briefly on the factual parts of it. This won't take a real long time. I want to overview for you this evening, because as your solicitor is going to let everyone know, we're also going to be given an opportunity to submit this to you in writing. And in my experience, sometimes it's a little easier to follow a procedural legal argument in writing than it is when someone's trying to explain it to you. So hopefully, when we get our proposed findings of fact and conclusions of law to you, this will come into a little better focus. Here's the bottom line. This isn't a special exception case. In a sense, I have to disagree with my client to the extent that she spent a lot of time this evening addressing the special exception standards in the zoning ordinance. Quite frankly, that's what she was presented with. They applied for a special exception, so on its face, the residents really don't have any other provisions of the ordinance to turn to and say, well, this is what you really should be considering. I wanted to discuss this at the outset, but I think everyone agreed they prefer to leave these sorts of arguments go until the conclusion. But what we're proceeding under, and I think everybody understands, is an application has been made under section 323 of the zoning ordinance, which is a section entitled Uses Not Addressed Within This Ordinance. And it basically says, if you're a property owner and your use isn't permitted anywhere in the township under the zoning ordinance, you can file an application to permit that use by special exception in any zoning district, and it would be subject to this board's review. And it does one other thing that's interesting. It flips the burden of proof. It actually makes if an applicant wants to do that, the applicant bears the burden of proof of establishing entitlement to the special exception. In a normal case, I'm sure this board recognizes special exceptions kind of a misnomer. Usually an applicant's entitled to a special exception, and the protestants bear the burden of proving that they did not meet the criteria. If you treat this as a special exception, they got all the burden. But the prerequisite to even proceeding under this section is that you're not allowed to do this anywhere in the township, and that is absolutely unequivocally, clearly not the case. This provision, if you think about it, why would you put this in a zoning ordinance? You'd put it in the zoning ordinance in an attempt to prevent someone from arguing your ordinance is exclusionary. Because everybody knows the zoning has to provide for all legitimate uses. If you add a clause like this, it's hard for an applicant to say, I'm not allowed. I am. I can slip in under this section. So case law that has to do with exclusionary zoning is really quite relevant to these proceedings. And quite frankly, I'd like you to do two things. First, if you look at the zoning ordinance provisions and you look at the definition of an industrial use, and I'm not going to read it again because I've read it to you several times. I've had witnesses read it to you. There's a definition of industrial heavy and there's a definition of industrial light. Well, if you go to the uses that are permitted in the industrial zoning district, it lists as a conditional use heavy industrial uses. If they were in an I district, they would be allowed to have a light industrial use if it was categorized as such. And in addition, it specifically says that a conditional use includes any use that utilizes or stores any hazardous substances as it's defined in Article 2 of the ordinance. Folks, this is an industrial use under the zoning ordinance, and it's not a special exception case. There's case law in Pennsylvania that supports this. This has happened before. People have tried to use provisions like this, and it hasn't worked out for them when they applied. I'm going to be giving you complete citations. In fact, I'll probably provide your solicitor with copies of the cases, but there's a case that was decided back in 1996. It's reported in 677 A Second Reporter 896, and it's the FICO case. In that case, we had an applicant that wanted to establish a bus depot. And they said, I looked through this whole ordinance, and in this ordinance there is nowhere the word bus depot applies. The ordinance must be exclusionary. I'm allowed to have my bus depot. Well, the Commonwealth Court looked at it, and they reviewed it, and they said, no, bus depot, if you go to the industrial, these are industrial cases, you go to the industrial district regulations, it allows truck terminals. Bus depot is a truck terminal. That's a reasonable interpretation of the law. So they were allowed in the industrial district, even though the specific words bus depot does not appear anywhere in the industrial district standards. And in that case, the court specifically held that for the purposes of determining whether an ordinance excludes a use, the ordinance does not need to mention the specific intended use, and a court or a board is supposed to reasonably interpret the ordinance to determine if there's another zoning classification that would allow it. In this case, industrial does. It also says that where a proposed use can be considered within another zoning classification, or where a zoning ordinance is broad enough to encompass the proposed use, there's no exclusion. And went on to again hold that a bus depot was substantially similar to a truck terminal, and thus it should have been processed as an industrial application. There's a second case. This one's a little bit more on point. This is the Grulich case, and the Grulich case was decided even earlier, back in 1987. In Grulich, they want to store explosive materials. They want an explosive distribution center. And they come back and they say, I read the ordinance. No, nowhere is this allowed. The court reads the ordinance and says, well, wait a second. In the industrial district, we allow warehouses or storage facilities. That includes a building for explosive distribution. What's interesting about the case is the court ruled that the fact that putting the use in an industrial district would be economically inefficient to the applicant didn't matter. They still lost. They still need to go in the industrial district. That economic hardship does not save them. So again, there's clear authority in Pennsylvania for the fact that you can't slip in under the special exception section if you're allowed in another section. And I think any reasonable interpretation of this ordinance would say that a metering station is a use that should be located in the industrial district. Having established that, well, one other thing I wanted to point out to you, there's another important reason why this should be considered industrial. If you read it, section 802.17 of the zoning ordinance, it has specific protections in there. The sorts of protections that we're talking about in this case for the public because it absolutely requires that the applicant get certifications from all government agencies that they're in strict compliance with any rules and requirements, and interestingly enough, also require them to supply the Township Emergency Management Agency and Fire Department with all applicable information, evacuation plans, emergency operation information. That's why we have an industrial district, so we have these types of protections for these types of uses. If they're allowed to proceed and slip in under this section, all this gets thrown out the window. If nothing else, it certainly tells you that these provisions have to be a condition. What's the bottom line to all this? They should have applied for a use variance. It's the only way that they're entitled to get relief under the zoning ordinance. Now I know, and I'm only going to say it once, they're going to argue that the zoning ordinance doesn't apply to them. We're obviously going to say it does. If it applies, they should be in an industrial district. There is absolutely nothing in this record at all with regard to meeting the standards for the grant of a use variance. There's nothing in here about whether there is even any hardship. For all I know, there's an industrial district located close enough that they could run their pipeline from there and set this up. But again, we're in the dark. We don't know that. They didn't file that application. They chose not to. If they're not going to seek the correct relief that's required under the ordinance, they're not entitled to an approval. Having said that, lawyers always argue in the alternative. Even if you were to assume that they're a special exception, again, they have the burden of proof in this case, and I'll just refer to my client's testimony and everything else that's been heard here. I don't think they've met that burden. And if they didn't meet that burden, that's reason number two why this application should be denied. If it were to be approved, then I think you would absolutely have to consider conditions in this case. When we submit our findings of fact and conclusions of law, and I suspect that maybe all the parties will be asked or will do this, those will be outlined for you. And I'm not going to belabor those or go through those again. Again, my clients are already done that. So legally, that's an overview of our position. Quite frankly, we don't think we should have ever gone through these proceedings. We think the application should have been different. If they disagreed with the zoning officer's initial analysis of the situation, they could have appealed that too. They could have appealed his decision. They didn't do that. If they didn't appeal his decision to the board that they needed board approval, they can't argue now. They've waived any argument that they're not subject to board jurisdiction. So no matter how you look at it under zoning law, and I'm a zoning lawyer, I'm not an environmental lawyer per se, I'm looking at the zoning law. When you strictly look at this from a zoning standpoint, this has not been pursued in the appropriate fashion. Having said that, I'd just like to summarize very quickly on the facts of this case. I think the case from a factual standpoint boils down to two words: peace and fear. Peace of mind, which is what my clients had a year ago before all this started, living in a rural area near a school where they never thought that there would be a threat to them, their children, or their families, versus the fear that they live with right now. And I don't care if that fear is a 10% fear or 1% fear or a 0.01% fear. That fear's there, and these folks have to live with it every day. In 30 years of practicing as a lawyer, I've learned one thing, and I've learned it very clearly. There's two things you don't do. You don't mess with a person's family, and you don't mess with a person's home. They're doing both. It's very, very, very upsetting if there's any risk being imposed, and that's probably why you saw as much emotion as you did in this case from the various residents. Having said that, having pointed out to you the legal standards that are involved in this case, I really don't think you have that hard a decision, folks. I think you have a choice of either supporting love of home and family are fulfilling a gas company's desire to maximize its profit at the expense of your neighbors and your children. And I would sincerely hope that you would protect the families and the children. Thank you very much.
Thank you, Mr. McNeil. Mr. Keller?
Sure. For myself and on behalf of my clients, I thank you for the attention, effort, and time you put into this appeal. As Mr. McNeil has stated, you're obviously not getting a princely sum for your efforts here, but those efforts nevertheless are greatly appreciated. Give you a little bit of good news. A lot of my argument was the same as Mr. McNeil's. I'm not going to repeat that part of the argument, so we'll save everybody a little bit of time on that. But what you have before you is a request for a special exception for a gas metering station in an A1 district. This is not a permitted use in an A1 district per the Dallas zoning code. It's not permitted by special exception in an A1 district under the Dallas zoning code. It's our position that this is actually a prohibited use under the code. It's prohibited because your code in section 502.3 specifically states any use which utilizes or stores any hazardous substance is a prohibited use in an A1 zone. In Article 2, your code defines hazardous substance as any material that by reason of its quantity, concentration, or physical, chemical, or infectious characteristics may pose a substantial present or potential hazard to human health or the environment when improperly treated, stored, transported, disposed of, or otherwise managed. You heard a lot of testimony since last February concerning natural gas. And I want you to take a look at Mr. Reza's testimony. Mr. Reza was very succinct in stating that natural gas in a pipeline is safe only if it's properly stored and transported. When asked about what safeguards we put in place in order to maintain safety of the pipeline, he said that Chief was going to have a wonderful program in place that's going to make everything safe, and if they complied with the program, no one had anything to worry about. But I asked him, well, what's the program? And he wasn't able to tell us what the program was. Therefore, in my mind and in the mind of my clients, there is certainly the potential for improperly storing or transporting gas through that pipeline. Doing so makes that gas a hazardous substance. When Mr. Scott testified, I asked Mr. Scott if he could guarantee that this would be a safe operation. He also did not have a listing of whatever the proper safety procedure or whatever the safety program was going to be, and he couldn't guarantee that this would not be presenting some hazard to the populace. Again, we can't tell you for certain, they can't tell you for certain, that this gas is going to be properly transported or stored, again making it a hazardous substance, thereby making it a prohibited use under section 502.3 of the zoning code. We all admit the gas can explode. An explosion would be something hazardous to the health of the populace. It's a safety hazard to the school. It's a prohibited use. You can't put it in an A1 zone. Even if you were to grant that section 323 could be used for the purpose of granting a special exception, again, it doesn't apply in this specific instance. Section 323 can be used only if the use is not specifically permitted or denied. Again, we submit that this is a prohibited use because it's a hazardous substance. Also, if you take a look at section 323, the use has to be similar to and compatible with permitted uses in the district. The uses in that district surrounding where this natural gas metering station is supposed to be put up are residential and a church, and there's some open spaces. This is an industrial activity, one that even Mr. Reza testified that gas accumulating within the building could cause an explosive event. It's an industrial activity being placed in a zone, in an area in which no other industrial activity is taking place. Therefore, it doesn't comply with that portion of section 323 of the code. Section 323 also speaks about hazardous substances. And again, it's a hazardous substance. Even were 323 to apply, you can't grant the special exception under section 323 because the use itself doesn't comply with the section. If you look at section 1510.2 of the zoning code, where it talks about special exceptions and the conditions that must be met in order to grant a special exception, it talks about not substantially impairing the value of surrounding properties. Mr. Coyle testified at length over 2 nights But I think it's significant to note that during his testimony, he never testified that he did an evaluation of property in Dallas Township and how this metering station would affect the values of properties. However, you did have homeowners come in and talk about location, 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 and the effect that they believe that the gas metering station would have on their adjacent properties. Also, you have to ensure that there's adequate public services, such as the streets. You heard testimony from EMT specialists who talked about what was required in the event of an evacuation. We heard testimony about the roads themselves that were surrounding this potential use. They're essentially small rural roads. If you have an evacuation, you had to evacuate this 1 mile radius, how are you going to evacuate them on these small 2-lane roads with the emergency vehicles attempting to come in and whatever transportation necessarily being used to take students particularly out of the area in question? The infrastructure simply isn't there to supply the needed transportation or evacuation routes necessary should the area have to be evacuated. Also, you have to have a sufficient infrastructure in order to guard against fire. You heard the testimony. There are no fire hydrants there. The only water coming into that area in the event of a fire is whatever the fire trucks and the tankers pull in themselves. The infrastructure there, it just simply isn't there in order to handle what may happen in the event that there is an explosion or a fire caused by something going wrong with this metering station. So therefore, the metering station can't be granted as a special exception under section 1510.2 because again, it doesn't meet that criteria. This is just a bad place to put a metering station. It's a bad idea to put a metering station there. The only reason it's being put there is for convenience of the gas company. What the zoning board really has to do is look at the interest and the safety of the residents of Dallas Township and put that at the forefront rather than looking at economic convenience of a group coming in from out of the area requesting them to grant you their special exception. And again, a special exception which we don't feel is even warranted or permitted under your own zoning ordinance. Thank you.
Yeah, just very few remarks, actually. We too appreciate the board's time and solicitor's time and all involved. As the board knows and as council knows, Chief Gathering has presented its case under protest, and it's important that it was presented that way to protect and preserve the legal rights Chief Gathering has in this case. Nonetheless, we hope and trust that you will feel that Chief Gathering has cooperated and participated fully to address each and every concern raised by the residents, by opposing counsel, and in particular the special exception process. I will also state at this point that it's, I know that the board will appreciate and the solicitor will appreciate that the arguments made by opposing counsel gave them latitude to both mischaracterize testimony and to misstate the facts as they were presented in that they either were unable or unwilling to present experts to counter the testimony of Mr. Reza and Mr. Coyle, and in fact rendered no objection to their testimony. And so we know that the board will appreciate that. So in respect of what we present to the board in our findings of facts and conclusions of law, we will accurately represent those. But we did, it was important to Chief, the final comment I had in respect of opposing counsel's comments is, I find it at least ironic that the suggestion would be that somehow Chief Gathering would slip in to an approval after the many months of testimony and the amount of time invested by everyone in this room, frankly. But Chief chose to feature the safety issues. We felt that all of the elements were addressed in the special exception provisions, but in particular, Chief Gathering understands and recognizes and appreciates that the safety issues are paramount. And that's why this gas metering station will be built, will be constructed safely, and it will be operated safely. It is important that not only structure be protected, that people are protected, and that no injuries or no incidents occur as a result, and that's the way it will be operated. With that said, will every resident of Dallas Township be satisfied if the board granted the approval? No. But I think the board has seen over time that many who started the process had their issues addressed, their concerns addressed, and their questions answered. And we appreciate the opportunity to have shared that information to address those concerns. As time passes, this gas meter station and the pipeline, which are benign activities, and the concerns will dissipate over time, much as they have for the gas meter station near Twin Stacks, that's near a daycare center, the gas meters next to the high school, the Transco pipeline. These are safe operations, and Chief has committed in the process to meet the most stringent safety requirements in constructing the station. So with that, again, we'll handle the rest of our legal arguments in our legal submittals, but we feel that we have addressed the provisions, and we trust that the board will not be swayed or deterred by those remaining opponents of the project to make clear that no science or expert testimony will satisfy them. Thank you.
Thank you, Mr. Comrade. Can I may have a moment?